Matter is remanded back to the learned family for court for fresh decision after appreciation of the entire evidence and record. Hence dismissed.
May it please your lordship. Lordship, I beg to mention item number 15, lordship. In this case, this matter become infructuous because he was shown arrested, lordship.
Number 15, it is submitted by learned counsel. Infructuous. Accordingly dismissed as
Highly obliged.
Wait, please, your lordship. Lordship, effective mention on I, my lord, for correction of order, my lord. Then inadvertent error, lordship granted bail, my lord, to my lord.
Wait, please, your lordship. Matter relates to correction of the order passed by your lordship in Lok Adalat. Let the matter be listed on 8th.
Obliged.
Please, lordship.
on
8th,
on
lordship.
10th.
8th.
8th. Oh, sure.
Correction in the order, my lord.
I don't know if it will come at 2.
Order mention only.
I seek permission for
Number?
bill application 913 of 2026 for
Item number.
our lordship. It is not listed today. It on 8th of April.
Go to see, earlier rejected by me.
No, lordship. It was last listed on 2nd of April. CT was to be called, but it is a charge. So the liberty and the bill application.
No, but why are you mentioning here, not before the senior bench? Made before the senior bench. Huh?
34, your lordship.
Yes.
I'm the new engaged counsel. Facts are missing in the bill application, your lordship. I will file an additional affidavit, your lordship. Person behind the bar, your lordship, 110.
34.
34. So fix the matter kindly, your lordship.
8.
Lordship, I want to mention item number 30. I am appearing on behalf of the petitioner and I have taken the consent from the respondent. We need 3 weeks time to file the reply in objection. And since the petitioner is out of town, so we need 3 weeks time. And the interim order may please be continued.
And for the respondent also. Respondent.
Prayer of learned counsel for the pit and on the consent of the respondent. In on.
May it please, your lordship. I beg to mention and anticipate more any deal, lordship.
Your bench.
But the sections are punishable below 7 years, your lordship. After tomorrow.
Below 7 years, this is not below 7 years.
Up to 7 years, your lordship. So punishment is less than or equal to 7 years.
Huh?
By this bench.
Special act. Even if it is less than 7 years, you have to go to the senior bench. Court number 24.
Obliged.
That is also punishment less than equal to 7 years.
Please, your lordship, I beg to make item number 43. Per the instructions of my client, I may be allowed to withdraw.
You want to withdraw? Item
43.
40. You are Mr.
H. Tapadar.
Eh?
H. Tapadar.
FR submitted. FR submitted.
There of Mr. B.H. Tapadar, learned counsel. Yes.
I pledge on the chair. I beg to mention item adjourned for
A
the.
little louder, I can't hear you.
There may be adjourned for the day.
It is
Another,
received.
another,
Alright, she did not receive list again on so and so. And?
and another bail application for withdrawal of bail application. The instruction of the petition.
Number, item number.
For listing,
Or listings, he's saying withdrawal. Yes, yes, go to senior bench.
Your Lordship, I beg to mention for listing, my lord, for IA, my lord, 8th of April, my lord. My lord, this urgency is that, my lord, London trial court issue a non-bailable warrant, my lord, against the petitioner, my lord. That case is already pending.
Why before this court?
But, IA, my lord, oh, my lord,
Go to senior bench.
Lordship, I beg to mention item number 46. In this matter, Lordship, charge has been filed before the London trial court, Lordship. So,
You want to?
Lordship,
What do you want?
withdraw, Lordship.
Where?
P. Das, Lordship.
Of Miss P. Das, learned counsel for the petitioner. Matter is dismissed as with. 6.
May it please your lordship. Here the petitioner is behind the bar since 24/6/2025.
NDPS. Commercial.
Intermediate quantity.
but here, such is submitted.
Charges has been submitted.
Copy of TCR along.
Right.
May it please your lordship. The regular bail application is your lordship. A custom seizure case, your lordship. Eric Arnott has been seized. The petitioner has been arrested on 2/3/2026, your lordship. He is the driver of the vehicle. And the truck has been loaded by the owner who assured him to provide the documents online. But as there was no document, I have been arrested. Number is at page 11.
Alright, CD.
Pleasure.
My lord, regular bail application, my lord.
Kindly have a look at page 11, my lord. Kindly see, my lord. Page 11, my lord. Translated type copy of the FIR, my lord. And vernacular, my lord, at page 16, my lord. A FIR has been lost, my lord, against one of the neighbor, my lord. All the petitioners, petition number 1 to 6, my lord, are their neighbors, my lord. There was no, my lord, any enmity in between, my lord, them, my lord, with the petitioner, with that of the, my lord, informant, my lord. But unfortunately, my lord, the petitioner got surprised, my lord. And in this case, though the, my lord, FIR has been lost against one person, my lord, petitioner number 1, my lord, the police has arrested, my lord, as many as, my lord, 7 numbers of accused persons, my lord, all the family members, my lord. And except petitioner number 6 is their near relative, my lord. My lord, there was no any, my lord, from the perusal of the FIR, my lord, there was no any motive, my lord, and malicious intention, my lord, of the petitioners, my lord. And, my lord, only on the basis of suspicion, my lord, they have lost, my lord. Some third person may, my lord, some instigate, my lord, something might have been happened, my lord. As there was some enmity, my lord, in between the petitioners with that of the next door neighbor, my lord. That, my lord, they have suspected, my lord, that the third person may have done the, my lord. So all the petitioner are already arrested, my lord, and they have already interrogated, my lord. My lord, further custodial detention, my lord, your lordships may, they will, any condition, my lord, they will, my lord, appear and cooperate, my lord, with the trial proceeding, my lord.
The forwarding report item, page number 19, grounds of 5. Mentioned that during course of investigation, it's been revealed that he was involved in the act of removing the state cow remains. Matlab,
Is
page 19, that forwarding report, grounds number 5. Tested on 6-3.
Yes, my lord.
I will give you.
there are material against you from the
My lord,
act may be simple, but ramifications are
my lord, your
wide.
lordship is absolutely correct, my lord.
Yes.
But, my lord, on any condition, my lord,
What con-
my lord, they will cooperate, my lord. Already arrested, my lord, and all the family members, my lord, including my lord, aged lady is also there, my lord. There was no, my lord, actually they have committed nothing, my lord, to hurt the feelings, my lord. There was no any such type of motive, my lord. Motive and malicious intention is, my lord, There is no any
Then what was the intention?
intention, my lord. On any condition, my lord.
What
we
was the
will
intention
cooperate, my
then?
lord. Any condition, my lord, is lordship.
Where is this from?
Kukra my lord.
We'll see on 8. Get the CD.
My lord, okay.
Obliged, my lord. And, one thing, my lord, in arrested on my lord, actually my typographical, there is 2025 is there, my lord, but it should be, my lord, 26, my lord. I may be, my lord. My lord, obliged.
My pleasure, Your Lordship. Malab, NDPS commercial case, malab, I am paying for CD only. From Sonapur PS. Per Bihu, malab.
On
23rd.
23rd.
23rd, malab. I'm obliged, my lord.
Yeah, please, Your Lordship. Lordship, commercial quantities in charge sheeted TCR may be called for, Lordship.
Alright.
Highly obliged.
27th.
Highly obliged.
Our sheet has already been.
It is a lordship, matter pertains to special act. It's a charge sheeted matter, charge sheet has already been submitted, matter. So at this stage, if lordship kindly call for
The
the
same
CPR.
order.
May, can it be on 30th of April? Ma'am? May will be 30th of April. If you understand.
Commercial quantity, my lord.
Right, same order.
Highly obliged.
There, Sashit submitted. There perhaps Sashit not submitted, CD is required.
Not submitted.
I don't know, 10.
Not submitted.
Sashit, yeah, lage, 28 crore. CD mal.
For the timing.
Okay, please, Your Lordship. Intermediate quantity, Lordship, CD may be called for.
CD.
40 days is behind the bar.
If 6th of May, 6th of May.
Intermediate.
Intermediate. Then 22nd mal. Today, 27 May. No, April. 27 April.
Deeply obliged.
Please, Your Lordship, the page number, Lordship, 24, Lordship. The 36 is not follow, Lordship. 36, Lordship. The page number 24 and 25, Lordship.
We have to see the CD. Yeah, along with scanned copy of the magistrate's order.
Well,
Your Lordship, petitioners are seeking anticipatory bail, Lordship. May I take your Lordship to page number 20?
Second,
Lordship, first.
your notice has to go.
Lordship, though POCSO is added in the case, however, Lordship, your Lordship peruses page number 22 and 23 of the charge sheet. Only section 368 is against the accused petition.
Page?
Page 23. Serial number 18, your Lordship will find. Charge, your Lordship.
Sir,
Yes.
your name?
Surat Lal Chauhan, serial number 5, 18.5, Lordship, and 18.6. 368 is only against the present petitioner, Lordship. The charge sheet accused number 1, POCSO is there, Lord. So I have made the informant as a party, Lordship. Section 368 is also not.
This we cannot make out what is the allegation against you. We have to see the CD.
Charge sheeted case, Lordship.
PCR,
May I plead immediately after the vacation, Lordship?
notice, my lord, otherwise.
Notice, I don't think for his case it is not required.
Yes, Lordship.
May I please, Your Lordship, my lord? My lord will find the affair at page 11, my lord. Lord, this is purely a love affair, my lord, and this has been admitted of the, my lord, victim girl, my lord. The informant has admitted, my lord, fourth line, my lord. For last 6 months, love affair between them is going on, my lord. The report says age is, my lord, between 18 to 19 years, my lord. She is a consenting party. My lord will kindly have a look thereafter at page 16, my lord. Charge sheeted case also. Will kindly come to, my lord, annexion number 2, my lord, page 16, my lord.
Even if we go by the
But there is no, my lord,
earlier part may be okay, but later part we have videographed and made viral. So
those are,
we
my
are,
lord, false allegations, my lord.
we are
With all
not very
respect, my lord,
sympathetic about that. We
my
have
lord,
to
we'll
see the
kindly have a
CD.
look, my lord, for a moment, the medical, my lord, opinion, doctor's opinion, my lord, at page, my lord, 16, the last, my lord, paragraph.
Doctor's opinion has nothing to do with the second
That, my
part.
lord, the girl is in between 18 to 19 years old, and there is no, my lord, mark of, my lord, any, my lord, kind of activity, my lord. No mark of injury, nothing is there, my lord. Her age is between 18 and 19 years, as per radiologist opinion, my lord.
Here on the second part.
I'll leave it to your lordship, my lord. At this stage, my lord, I'm praying for interim, my lord, if possible. Can be some protection, my lord.
This stage, my lord, TCR may be called for an
Yes.
notice may be issued.
My lord will kindly, my lord, consider my interim trial, my lord.
We are not at all sympathetic in these matters when you make video and viral and all that stuff.
Twenty-eight,
It post AD.
Definitely.
It please, your lordship. This is a 482 application. The sections which have been imposed 25 and 29 of the NDPS Act. Now, the matter has been charge sheeted on 31/12/2023, and I'm the registered owner of the vehicle.
Can copy of TCR along with CD. Obliged.
Made to reserve losses. Petition is anticipatory bail, my lord. Lordship kindly peruse the FIR.
Yes, page.
Page, lordship, 14. Incident took place 23/10/2025, Lord. But the FIR lost 25/12/2020. And POCSO is added later on, recently, my lord, in the year 2026. Petitioner is a student, my lord, and girls were recovered on the same day, my lord. And POCSO also added later on, my lord, 28/1/2026. Annex that order.
Third
Okay,
learned
but
counsel
made
for the
it-
petitioner and learned.
But they have not made the informant as a party.
No, why not? To make the informant a party.
Subsequently, but now POCSO is there.
Yes.
Petitioner is a student, my
What
lord.
to
They
do now?
fall in love each
They
other.
have to file a,
My lord, lordship pass an order, I will make party, my lord. Amended petition.
That petition. The informant as a part. When?
Before to
Again on.
my lord, 8, my lord, I will file today itself. Fix this matter on 8. Highly obliged. Who is the lordship?
Charge sheeted. CD. Notice to respondent
notice.
number 2. Speed post with AD within 3 days.
Yes, bail application, lordship. The petitioner, lordship, is the owner of a truck, lordship, page number 12, lordship. And his truck was seized by the Shivsagar police, lordship, while carrying cattle, lordship. And 41 numbers of cattle were recovered from his vehicle, lordship, and accordingly, said vehicle was seized along with other vehicle, lordship. And present petitioner, lordship, his vehicle was hired by one Abdul Basha, have categorically mentioned in page number 4, lordship, paragraph number 4. FIR, lordship, will find at page number 8. May I read the paragraph 4, lordship?
Yes.
The petitioner begs
No
to state-
permit, no nothing.
Lordship?
Not produce anything
So, lordship, I don't know.
in
But
violation of the provisions of Cruelty Act.
the violation of the cruelty is a bailable offence, lordship, as per the to my knowledge, Lordship. But the Assam Cattle Preservation, Lordship, as per the FIR will not attack, Lordship, because they have mentioned in the FIR at page number, your Lordship, may kindly see page number 9, Lordship. Paragraph 5, as per the FIR, Lordship. It is strongly suspected that the cattle were being transported for purpose of illegal slaughtering, especially concerning that Shivsagar district shares an inter-state boundary. There's mentioned that Lordship, the Shivsagar district shares an inter-state boundary. No, Lordship, as per the Assam Cattle Preservation Act, the Cattle Preservation Act will attack only, Lordship, if the cattle were seized in the district where the international boundary is shared, Lordship. Like Dhuburi, Karimganj, Lordship, they have shared international border. No, it's an more or less, Lordship, in Assam, it's an every district shares inter-state boundary, Lordship. It cannot be an offense as per the FIR, Lordship. Because of that, Lordship, the Assam Cattle Preservation has been attacked, Lordship. Whatever it has been mentioned in the FIR, I am not. But Lordship, the petitioner is the owner of the vehicle, Lordship. Let him appear before the IO, Lordship, and produce his documents, Lordship, who has hired his vehicle, Lordship. Moreover, Lordship, his vehicle also lying in the police station for more than 3 months, Lordship.
We waited for 3 months, then wait for another 2 weeks.
Lordship,
You can, if you have that much resources.
Second,
Now, Lordship.
Yeah, please, your Lordship. Lordship, matter may be passed over for the time being, my senior number 9, Lordship.
My lord, then just for some time, Lordship.
May I please, your Lordship? 10 of the POCSO Act is notice. Highly of
CDM notice. My lord, on 28, my lord.
highly obliged.
Chip. The instant matter is involving sections of POCSO Act. The instant application is one for anticipatory bail. At this stage, it is great that notice is issued and the case diary be called.
Of
Much obliged.
anticipated bail application in connection with Gusaigaon PS case number 48 of 2026 under section 64(1) of BNS and section 4 of POCSO, your Lordship. First, notice may be issued and CD may be called for, your Lordship. Further, on 6th of May. Highly obliged.
Secondly, timing also. Timing, my land consolidation after.
May the matter be for the time.
Time being 20. Can I have FIR page 10? Actually, internal page at Bhanegula 15. There is a fine. Monetary lender is known to other informant, known to the petitioner accused.
He was a tenant under the petitioner. Came to the visit the house of the informant for asking the money of rupees 55,000 for taking back. But instead of giving payment, he has taken the shelter of this criminal.
Anyway, notice has to go.
Hello?
Notice has to go anyway.
Hello.
POCSO is there.
Next step.
Same.
Yeah, my lord, court of
First one.
Please, your lordship. Yeah, please, your lordship. Lordship, the present application is arising out of a matrimonial dispute. So, let the respondent, they have not filed their affidavit. So, in the meanwhile, if they file it, then matter may come up for admission, your lordship. Similar matter has been listed in court number 24, your lordship.
File affidavit, that is for him to say.
Lordship, we have to file Wakalatnama also.
You are entering first time. Your name is?
Respondent to not reach Gauhati for some difficulty, we will be filing today. We will file affidavit also.
Third learned counsel for the petitioner. Hearing for submits that he would be filing Wakalatnama in the course of.
Lordship. Interrupt your lordship. Lordship, already talks of settlement are going on between the
Hearing
parties.
order, if any,
So
that
can we
continue
fix
till
after
the next date of listing?
Absolutely. Deeply authorized.
This matter may be possible for the time being, Lordship. Council TG Mohant is in lag in another court.
May it please your lordship. Pandibe's commercial quantity, charge sheeted lordship. In this case, lordship, I am behind about since 252 days as on today, lordship. My case, lordship, petition not been produced within 24 hours, lordship, before the learned magistrate, lordship.
Yes, PP.
Lordship. Sanction will be shown as page number 19, Caesar list, lordship. Here one date and time, 28/7/2025 at 1 AM, lordship.
Where page?
In page number 19. That is Caesar list. Date and time, lordship.
And Lordship, the notice served upon us, Lordship, case number 38, Lordship. That's 38, Lordship. Here in page number 39, Lordship, the arrest, date and time of arrest, Lordship, on 28/7/2025 at 10 PM, Lordship. That is in the night, Lordship.
28.
And produced on 29, Lordship. And production order, Lordship, in forwarding, Lordship, forwarding in page number 15. It is forwarding dated 29/7/2025. After 24 hours, Lordship, within 4 hours, not been produced, Lordship. And that's, Lordship, my fundamental rights has been violated, Lordship. In this regard, I want to refer a judgment of Honorable Supreme Court, Lordship. And also bail granted by the coordinate bench.
Yes, where is the remand order?
The remand order is not annexed here, Lordship, but the TCR might show, Lordship. TCR is available, Lordship.
Where is it with you?
That is the room.
So he was arrested on 28.
arrested, but as per the observation given by the Honorable Supreme Court, time starts from the physical custody, Lordship. Physical custody was taken, Lordship, FIR will also show, Lordship, in page number 14. The list already shown, Lordship, that is the midnight at 1 a.m. Lordship.
You see, the 24 hours will expire at midnight 1 a.m. on the next date.
On 29,
It
yes.
can
in
be
the evening,
produced
Lordship.
only when the court reopens.
Reopens at 10 a.m. Lordship, but it ends at 1 a.m. Lordship on 29. That is in the evening, in the morning, Lordship. But
Where is it? Where is the time given?
time given in page number, Lordship, in 19, Lordship, Caesar list.
How can Caesar list show the time of production?
Time of production, Lordship, forwarding is there, Lordship. Forwarding is.
Forwarding does not mention the time.
Time not mentioned in the forwarding, Lordship.
So what are you trying to submit?
Already, I have to refer the Supreme Court judgment, Lordship.
Before that, let us get the facts clear what you are trying to submit. Then only we can apply the law.
Yes, Lordship. Lordship, in page number 19, Caesar list, date and time, that is 28/7/2025 at 1 a.m. That is night, Lordship, in the morning. And
information was received on 27
yes,
at,
Lordship.
at 10:30. They proceeded at 11:30. Then made the search and seizure at 1 a.m.
1 a.m. Lordship. That is physical.
By then it became 28.
Lordship, physical custody has been taken and it will
Yes.
show in the page
So the 24 hours will expire at 1 a.m. on 29th.
29, yes, Lordship.
Midnight.
29, but court will.
At 10 a.m. they have produced.
They have produced after 10 a.m. Lordship.
How can they produce before that?
Court opens at 10 a.m. Lordship. If you presume that the petitioner has been produced at 10 a.m., it will exceed at 24 hours, Lordship, because 24 hours will complete it at 1 a.m. Lordship.
What will the police do for the court opens? Where will he be produced?
Might produce.
Where was he arrested? What is the place of arrest?
Place of arrest, Lordship, in notice will show, Lordship. In page number 36. In page number 39, Lordship, will show, Lordship. The time of date and time of arrest. That is the formalities, Lordship. The formalities, but physical custody was taken at 1 a.m. in the morning, Lordship, on 28th. As apprehended, that will show in page number 14, Lordship. Lordship.
Yes, PP.
I take the lordship to my lord, page number 15, my lord, forwarding. Kindly come to the first, second paragraph brief of the case, my lord. 27/7/2025 at about 11:30 p.m., my lord. Information. Now, lordship may come to next paragraph, my lord. There is the residence of Yunus Khan. I am reading for the middle portion of the paragraph, my lord. Yunus Khan, ward number so and so, Assam, on 28/7/2025, 12:30. 12:30 a.m., my lord. 28/7/2025, early morning, 12:30 a.m. They reached the house of the my lord accused. Then, my lord, as per legal formalities conducted the house search in presence of witnesses. Before search, the following two independent witnesses who were found near the PO were approached by the complainant and they were explained the purpose of search. He also requested them to witness. Thereafter, my lord, 12:30 a.m., my lord, they started the house search, my lord. Then Caesar, as per the Caesar memo, my lord, 28/7/2025, 1 PM, my lord. Caesar list was prepared, my lord. After that, my lord, the accused person was taken into custody, my lord. Now we have
Let us say
by-
2:30 PM.
Yes, my lord, we have to go by the, my lord, the arrest memo, my lord. At what time the arrest memo furnished, my lord? Because till the house was searched, my lord, the accused person was not taken.
Anyway,
into
they
custody.
arrived at Dhubri PS at 2:20 AM.
Yes.
So the arrest, let us say arrest was at that time, 2:20. Word number 10 to Dhubri PS.
Yes, my lord. Yes, then, my lord, he was produced, my lord, as per the forwarding report on 29/10/2025 at 10 AM, my lord. That night, my lord, they cannot be produced, my lord. Facts are clear from the, my lord, from the materials of the materials, my lord, for annexed by the, my lord, my learned friend, my lord. And it is also clear from the scanned copy of the record, my lord. The accused person cannot produce before the trial court at midnight, my lord. So what is the wrong, my lord? We have to go by the arrest memo, my lord. Caesar, till, my lord, the Caesar is made, my lord. What my learned friend is trying to point out, my lord, that 28/7/2025, 1 AM, my lord. Till preparation of Caesar list, my lord, he cannot say, my lord, he was arrested, my lord. How can he say, my lord, that he has been taken into custody at 1 PM, 1 AM, my lord?
Yes, I can show lordship, that is page 14 lordship, in FIR lordship. FIR start 13, that is in page number 14 lordship. The second para lordship will show that the persons, namely Yunus Khan, Yusuf Khan, both are son of so-and-so, were apprehended lordship. I was apprehended lordship.
But whether, my lord, after Caesar it is apprehended, my lord.
Yes,
It
after
is mentioned
seizing,
that, my lord, after Caesar, my lord, he was taken to the police station, my lord. The time is not mentioned, my lord.
He was taken to the police station at 2:20.
20, yes, lordship.
Yes, 2:20.
That Honorable Supreme Court already given the observation very clearly, lordship.
Because from the, my lord, time, my lord, when he was arrested, my lord, that is 28/7/2025 at 10 PM. And production, my lord, on the next day, 2 PM. In, my lord, 24 hours, my lord. That is considered in my arrest memo and the date and time of production, my lord.
That is not the dispute, lordship. That is the
Arrest memo, you can show a different time, but from the forwarding report itself, it is an admitted position that he was effectively in your custody at least by 2:20 PM. Before 2:20 PM. AM, sorry. Next day by 2 AM time would expire.
2 AM time expire, but 2 AM, my lord, the person cannot be produced, my lord, at 2 AM. That is why in the early morning or at 10 PM, at 10 AM, my lord, they were produced, my lord, accused person, my lord.
there is the possibility to produce on 28th also, lordship, because I was apprehended at 1 AM, lordship. Taken to the police station at 2:20 AM.
I will examine.
Obviously.
Lordship, on the last occasion, Lordship have pointed out that whether we had challenged a order taking cognizance, Lordship have pointed out whether it was appealable order or not. That regards, Lordship, I just wanted to confirm whether it was an interlocutory order or final order, Lordship. Will like to, if Lordship gives liberty, Lordship will move the forum with a limitation.
Prayer of learned counsel for the petitioner matter is has withdrawn with liberty to move the appropriate forum.
Lordship, Limitation Act, Section 14 of the Limitation Act.
That you have to plead before that court.
Lordship, anticipatory bail application. Fire is on page 14, your lord.
The story basically behind the case is that the main accused, along with the present petitioner, were given a shipment of peas to carry to various states of the Northeast, carried from Azra. Thereafter, due to some lack of communication and not being able to know where the truck was, the owner filed an FIR, the owner of the peas. Then the vehicle owner was arrested, Your Lordship, and I was the driver who had given the charge to the owner himself due to the vehicle not being able to run properly. Forwarding of the main accused is on page 21.
You are the driver.
Yes, Your Lordship. When while traveling, the vehicle had some issues. He contacted the owner. The owner came, took the charge of the vehicle from the present petitioner, and then the present petitioner returned to home.
FIR does not say so. FIR says owner said we do not know.
That is the owner of the vehicle, Your Lordship, who is the accused who is caught. He is the one who has implicated the present petitioner in this case, Your Lord. The FIR was lodged by the owner of the peas, goods being transported.
All right, CD.
Lordship, interim can be granted, Lordship. Lordship already knows that breach of trust and cheating cannot go together anywhere, Arshad Niaz Khan.
Either can.
So there's a, will go around 21st. First to go. Once.
Obliged.
Yes.
May I please, your lordship? My lord, this is a pre-arrest bail application, my lord. My lord may be pleased to find the FIR is at page, my lord, 17 of my petition, my lord. Lord, and it's a long FIR caused by the police itself, my lord.
You are the what? Driver, owner?
No, my lord, I am the owner of the Brahmaputra goat supply, my lord, and I have purchased and, my lord, was on the mode of transporting the my lord, animals along with the, my lord, license vehicles, as well as by, my lord, completing all the formalities, my lord. I was while transporting, the Khotkoti police, my lord, intercepted my vehicle, my lord. Those loaded with 25 numbers of buffaloes. Now, my lord, the police asked the documents, and the documents when exhibited before the police, my lord, police did not, my lord, was satisfied with those documents, and, my lord, this case had been lost. Saying that, my lord, section 31 of the 31.3032 of the and 35 of the BNS, along with, my lord, this various section of the Prevention of the Cruelty to Animals Act has been, my lord, registered. Now, my lord, I beg to draw
Where are you here in the FIR?
No, my lord, it has not been named in the FIR, my lord. I have not been named, but my lord, this, my lord, notice had been issued in my name, my lord, asking me to appear. My lord may be pleased to find the notices which had been issued is at page 34, my lord, under section 30.
According to you, who are you? You are the purchaser.
The my lord Brahmaputra, my lord proprietor of the Brahmaputra goat cattle supply, dealing with the livestock business, my lord, and this is admittedly my property, my lord. I had purchased it from Dimapur, and on my vehicle, my lord, licensed vehicle, it had been transported, my lord, with all valid documents. I just want to draw my lordship's kind attention, my lord, to the, my lord, may kindly turn to page 48, my lord. My lord, for this kind of transportation, my lordship knows, my lord, that this type of health fitness certificate from the concerned authority is required, my lord. So this is a certificate issued by the, my lord, government of, my lord, the concerned doctor, my lord, issued on after the purchase of these properties, my lord, wherein it has been said that the buffaloes were in very, my lord, healthy stage, my lord, and it can be transported, my lord. Two certificates, my lord. One is at page 48 and another is at page 50, my lord. For total 25 numbers of buffaloes, my lord. So, my lord, the allegation of the theft, my lord, is not at all, my lord, admissible that I have committed theft. These properties, this is a valid properties, my lord, had been purchased from the seller at Dimapur, Nagaland, my lord, and while transporting, and even my vehicle, my lord may be pleased to find the vehicle is also designed in such a manner, my lord, that the vehicle can be used for the purpose of, my lord, transportation of these animals, my lord. My lord, may kindly turn to page number 42. 44 is the documents, my lord. Now, my lord, I am ready to cooperate with the investigation, my lord. I will go and, my lord, whatever documents and whatever the materials are available with me, my lord, I will satisfy the investigating officer. But, my lord, as the notices had been issued and the cases had been, my lord, registered in non-bailable sections, my lord. So I am apprehending that I may be, my lord, arrested, my lord. So my lord may be pleased to kind enough to, my lord, give me some protection so that I can go and cooperate with the investigation, my lord.
Kindly come to page number 20, my lord. Page number 20, my lord, third paragraph, my lord. At Kalirampurti's 4-line Nakaseking point, on being asked to produce documents regarding transportation and ownership of the buffalo, the person present with the vehicle failed to produce any valid documents regarding purchase, ownership or lawful possession of the buffalo. During the checking process, the driver and handyman of the truck bearing number so-and-so, with 6 buffaloes were loaded, managed to flee away from the spot, taking advantage of the darkness, my lord. Chapter 1 of page number 21, my lord. Third paragraph. Next page, my lord. Next page, my lord. Page number 21, third paragraph. During inquiry, driver Hakim Bhuya further stated that the buffaloes were being transported from Dimapur to Gauhati and that the owner of the buffaloes is one Rafiqul Islam, my lord. Mobile number so-and-so. So, my lord, he could not produce any documents, my lord. If he has got possessed the valid documents, my lord, why it was not, my lord, sent along with the buffaloes, my lord. The valid documents should be along with the truck, my lord, in the hand of the driver, my lord.
No, my lord, my lord, our instruction is that it was with the driver, though it was produced, my lord, but the police has, my lord, said that they could not. Now, it is the version of the police, my lord. It is very difficult for me to prove, my lord.
The documents were with you. Why did you have to run away?
No, my lord. My lord, even we did not run away, my lord. A habeas corpus petition had been filed before the Honorable Division Bench, my lord, for illegally confining these persons, my lord, by the police. My lord, when the habeas corpus petition was filed, then only this case came to be registered, my lord. There are certain issues are there, my lord, which I have not, my lord, has not stated before my lord, my lord. When the habeas corpus notice is issued, my lord, then this person had been released, my lord. This Rafiqul Islam and other, my lord, my mans, my lord, who were accompanied with the vehicle, my lord, then they were released by the police, my lord, after the notice by the Honorable Division Bench, my lord. So, my lord, with all respect to my respected friends, my lord, that the driver could not produce the document, these are all, my lord, factual issues, my lord. It was with the drivers and other persons available there, my lord. But, my lord, at this moment, as I have issued, received a notice, my lord, I will go, my lord, and I will try to satisfy the investigating officer that these are not the material or the animals which have been committed, my lord, has been transported by committing theft, my lord. We have the valid document, we have purchased, my lord, and I am doing this business regularly, my lord. Lord, something is there which I cannot disclose before my lord, my lord. The amount of pressure the police is exerting upon me, my lord. So, my lord, some protection may be given, my lord. I will cooperate with the investigation, my lord. If something is arising out, my lord, that my involvement, then my lord man can, my lord, dismiss my petition also, my lord, after the perusal of the CD, my lord. My lord, if I committed a theft, my lord, then this certificate issued by the Nagaland authority, my lord, would not have issued, my lord, the prima facie documents, my lord.
It was not produced at the time of my.
No, my lord, it is the version of the police,
My lord,
I
in
am.
all the, my lord,
My lord.
this kind of bail application, lordship will find, my lord, all the documents along with the bail application. But they could not produce any documents when the vehicle was intercepted or the cattle were seized by the policemen.
No, my lord, one incident cannot be generalized, my lord, with all respect to my senior friend, my lord. This is not a, my lord, I am doing the business very fairly, my lord. There is nothing illegal on my part, my lord.
Learned counsel for the fire. Briefly stated. Is the date of interception?
My lord, the date of interception is, my lord, 10/03/2026, my lord.
Confluential. Trucks belonging to the British cattle. Eight vehicles were intercepted by the police at Gauhati. Of the driver is see cattle, but the driver and handyman of the truck fled cover of darkness. Of the seized cattle as well as the typically designed for transportation of livestock and validly conducting his business. There is no problem as he has in his possession all the necessary documents. Certificate of fitness issued by the veterinary department in to the transported cattle. Give the notice under Sec 5 BNSS. All are non-bailable. Court by way of the instant application. FIR, wherein it is stated that driver failed to produce the necessary documents. The aforesaid sub that said documents were present with the petitioner, with the driver, but the police ignored the same and has resorted present and has instead lodged the instant call for the CD para having regard to the submissions of the documents annexed to the bail application. Added that the event of his arrest connection with the aforesaid case shall be released on interim bail of rupees 50,000 with securities of like amount to the satisfied. It is further provided IO along with all necessary documents within 10 days from to for the purpose of interrogation. Again on
34.
Obliged, my lord, deeply obliged, my lord.
Yes, POCSO.
But this is a regular bail application, my lord. POCSO matter, my lord.
6.
POCSO matter, my lord. Kindly see the page number 25, my lord. Page
12.
number
Huh?
25, page number 25, annexure number 4. My lord, in this case, my lord, what happened, my lord? After filing charge sheet, my lord, with showing the respondent are accused person. Later on, my lord, the accused person prepared a criminal petition for quashing the NVWA and AN. After that, after hearing the both sides, the Honorable High Court passing an order, my lord, kindly see the page number 26. 5. Next number 5, page number 26.
Yes, what happened?
After getting this order, my lord, the accused person appeared the trial court for applying the regular bail, but the trial court not consider take the bail and send the judicial custody the accused person. While the Honorable Gauhati High Court 10 days time and 10 days in 10 days, my lord, the accused person appear on 5th February 2026. Honorable High Court passed order 28 January, my lord, within the 10 days, my lord, that period, my lord. But the trial court not consider, my lord, in the judicial custody, my lord. That they reject the bail application by the trial court, my lord. Hence this regular bail application, my lord. It's very difficult, my lord. 10 days time for release the bail, my lord. In during that 10 days, my lord, the accused person is at trial court, my lord, not consider, my lord. When filing the bail petition, my lord, High Court order, my lord, not consider the trial court, my lord.
Court below, we should notice to the respondent since you were seeking bail.
Yes, my lord. That, my lord, within 10 days, my lord, may not be, my lord, send the.
Within 10 days, you were only, it is on your submission.
It will be available on the bail, my lord.
It is on your prayer that you will appear and
that period,
Until then, the NBWA and PNA was
Suspend, my lord. That
kept
period of
in
10 days, my lord,
abeyance.
already suspended by this
No
honorable.
bail was granted by this court, nor was there any direction to that court to
Already, my lord,
grant bail.
NBW, PNA, my lord, suspended by this honorable court, High Court.
Till
10 days, my
then,
lord, IPR.
only till then.
Within 10 days, my lord. No, within 10 days, my lord. 10 days is clearly marked, my lord.
Yes, after
Within
you
10
appear,
days,
it is for
IPR,
the
my lord.
magistrate to decide.
Yes, my lord. Within 10 days, my lord, IPR.
Now you have come with the fresh bail application. So same process, we have to issue notice.
That's true, my lord. Boxo matter, my lord.
And copy of TCR alone.
Hola, señor.
Hey, please, your lordship. But 483 application, my lord. Where at page 17, my lord. This is a POXO matter, my lord. The case is in argument stage, my lord. But in this case, the FIR was lost on 1/10/2024, my lord. Thereafter, accused was arrested on 2/10/2024. My lord, SARS was framed in this case on 27/11/2024, and thereafter, my lord, 10 numbers of witnesses has already been examined, my lord.
So you are happy to remain in jail throughout the course of the trial, and now when argument stages come,
my lord,
you have come for
my lord,
bail.
I am coming. My lord, the 313 statement was taken. My lord, kindly peruse at page 62. SARS was framed on 28th day of August 2025. Then, my lord, kindly come at page 67, my lord. 67, 28/8/2025. The case was posted for argument on 6/9/2025. Until then, my lord, this case is pending in argument stage because the court is laying vacant, my lord. Within 8 months, my lord, the entire procedure of the case has been completed, and another about 9-10 months are pending in argument stage, my lord. So it is long incarceration, my lord, due to pending of the case. My lord, my another submission is that, my lord, kindly peruse at page 26, my lord. Page 26, my lord.
There is the deposition of the victim.
Victim deposition at page, my lord, 41. Victim's deposition at page 43, my lord.
The court still vacant.
My lord, the
Hmm?
court is still vacant, my lord. My lord,
Could have applied, you could have applied to the session judge.
lord, apart from this ground, my lord, kindly see at page 26.
Otherwise, you have been squarely implicated.
My lord, kindly see page 26.
14-year.
Here is the
16.
ground of, I am not on the merit, my lord. I am on the law point, my lord. I am
Hmm.
paying for the bail on law point, my lord.
Yes, what
That
is
is
the
at
law
page
point?
26, my lord.
Hmm?
Kindly peruse at page 26. At the time of arrest, my lord, the notice was served under section 47, my lord, but the notice was not properly served, my lord. Because in this notice, my lord, the ground of arrest is not mentioned. There is no column of ground of arrest, my lord. And moreover, my lord, this notice is written in English, my lord, and the person arrested, he put his thumb impression, my lord. And the notice under section 47, my lord, should be clear, real, and not mechanical, my lord. But in this case, it is a mechanical, and this is not a proper format also, my lord. Not the format. Just in the name of notice, this notice has been served. And in the same case, my lord, this honorable, I have submitting, my lord, I am submitting 3 judgments, my lord, that if the notice has not been served properly, then the accused will get the benefit of bail, my lord. I am submitting 3 judgments of this honorable court, my lord. On the same subject matter, almost the same subject matter, my lord. And in Bihan Kumar judgments and other 2 judgments, my lord, it is clearly says, my lord, the notice must be clear, real, and not mechanical, my lord. Notice should be sharp, inform should be given, and ground of arrest must be mentioned, my lord.
PP.
On merit, my lord, he is not an. The ground of arrest, my lord.
Thing is there.
Artist on 2/10/2024, my lord. But Purkasto was the first case, my lord. I'm sorry, before the Ramkishore Arora, my lord. Ramkishore Arora came on 15/12/2023, my lord. But my lord, Prabir Purkasto, then Bihan Kumar, my lord. Sir, Ramkishore Arora, my lord. In 2023.
Is the date of this arrest?
Date of arrest was, my lord, 2/10/2024.
Tell me, my lord, why at this fake end of the trial, my lord? He could have taken this ground before trial could also. Argument is this, my lord. Standing officer, my lord, matter.
The submission regarding these judgments, Pravir Purkar,
Yes, so my lord, that was the judgment, my lord. Test of 15/5/2024, my lord. 2024 8 SCC 254, my lord.
date of arrest is
Date of arrest is, my lord, 2/10/2024, petitioner, my lord.
after Pravir Purkar. Stringent conditions.
Strict conditions so that, my lord, appear, my lord.
I will appear, my lord.
Passwords. Yes, next item.
Obliged, my lord.
Lord, anticipatory bail application. My lord, FIR may be seen at page 17. My lord, it involves, my lord, 8.1 gram of suspected heroin, my lord. 21B. My lord, petitioner is a widow, my lord. Her husband died in the month of January, my lord, leaving behind her and two minor children. My lord may call for case diary and some protection, my lord, leniency, my lord.
Was recovered from your house.
But I was not there, my lord. My husband was in a.
But your husband is dead. In a case that your husband is alive, it is found, then we would have
At that time,
thought that you had no involvement, but
that time, my lord, he was alive. But
Huh?
I have annexed
11/1/25.
lordship. Now, my lord, death certificate I have annexed page 22. Here, page 24. Husband died on 26/1.
Earlier case is also there against you.
Case number 26, my lord. 27/4.
Obliged.
Eight pleases your lordship.
My lord, the offense is of 60 days offense, my lord. Punishment extending up to 5 years, my lord. The allegation in short is that the petitioner has tried to touch the body of the daughter of the informant, who is 9 years of age, by trying to lure her by paying 50 rupees. My lord, your lordship will find the FIR at page number 8. The FIR is lodged after 5 days of the alleged incident. The incident is of 31st January 2026. The FIR is lodged on 4th of February 2026 without there being any.
Has been fully implicated. Third learned counsel for the Smith. The allegation, the FIR. The victim is a deaf and dumb girl, 22 years, and the absence of her person entered the house time and times keep upon her, as a result of which victim became pregnant. Statement of the to the gravity of the alleged of the
Alia.
Please, your lordship. In this case, my lord, the case diary along with the health status report of the accused was called for, my lord.
Actually, already submitted, my lord, in this case.
this scan copy.
We will actually submitted, my lord, by CS number 49 of 2026, dated 13/3/2026.
It scan copy of the TCR along with CD.
7 May. Deeply obliged.
Lordship, matter may be fixed on after vacation, your lordship, because
Head of learned counsel list them after the vacation.
May please. The petitioner is in custody since 17 to 2026. Lordship. On today, 48 days in custody. Your Lordship will find page 13. Intermediate quantity was recovered, Lordship, and mandatory period is 60 days and already 48 days in custody. First time offender, Lordship, found that bill payer may be considered.
Over from his possession, my lord. There is, my lord, at least pending for to collect the FSL report, my lord.
Apply the same standards regarding period of detention when NDPS case is concerned.
Your Lordship, if your Lordship see page 14, that contraventions, first contravent that is recovered nitrosamine, that is 35 gram and commercial is 500 grams. The second, Lordship, that other contravents which were mixed with tramadol, those are not NPS substances, Lordship. Cyclomine and that other capsule, those are not, so I'm not, FSL is not there, so I'm not commenting on that, Lordship. Other also, Lordship, that
You are a peddler.
he is a first time offender, Lordship. Earlier, no previous.
You will not carry commercial quantity when you are caught.
Antecedent also considering that aspect. Lordship. And other, those are, Lordship, contraband, Lordship, only that number 1 is above. Lordship. Number 3 is below commercial, that is intermediate, Lordship. That small quantity is 5 gram. Number 3, Lordship. But to other quantities are recovered mixed, so I am not on that.
You cannot be on that also. That is also to be counted.
So if other tablets the person has mixed, Lordship may kindly see that weight of the dicyclomine that is separate tablets. And Lordship that after tramadol and acetaminophen capsules. So those are not the DPS substances, Lordship. They have mixed it together, then Lordship it is come to 127. That also, Lordship. Others are just above small quantity. That part and the first time offender, Lordship. Yes, and also, Lordship, that study period will be over, Lordship. It is kept. Courts will be there with the investigating police officials also. If he enters in similar offense, certainly those.
Yes, PP.
Amazon, my lord, this, but from his possession, my lord. The court will only reveal, my lord. The contraband are, my lord. Except the, my lord, the brown sugar, my lord. Also implicated in, my lord. Collect the FSL report, my lord. Pending to collect the FSL report.
case called for has been the quantity of narcotic drugs, nitrazepam, tramadol tablets,
Page 13, the last paragraph, your lordship.
petitioner.
Measures of the accused.
Premises of the accused petitioner. Yet to be collected. But investigation is already regard to the period of 48 days. And there is a first time offender. Try to tamper with the evidence or
My submission may be recorded.
My lord, this is for quashing of a criminal, quashing of a DAV case, my lord. My lord, if your lordship, my lord, record was not called for. Without record, if I want final disposal. If your lordship, my lord, dispose of the matter without, my lord, calling for the scanned copy of the order, and I have no objection, my lord. But they have not filed any affidavit also.
have it then. Learned counsel for the
Is at which they come up was after the issuance of the notice. The complaint was there and the order was there. Both of Section 12 application as well as the order by which notice was issued, both of them have been, the petitioners have filed those, my lord. Courts, my lord, other orders, my lord.
we are going to go for final disposal, then we'll have to have it
My lord,
today.
my lord, any date, my lord, after vacation, my lord.
As per my learned.
My lord, I'm always there. Little accommodation is required. I'm sorry, my lord.
Care of learned counsel for hearing did not be
Order pass alia self-control. Order pass alia self-control. Oh, 23rd. No?
I'm deeply updated.
May I please, your lordship? Lordship, translated type copy to FIR page number 20, lordship. May I read, lordship? Election was there, lordship, today on 11/2/2026 at around 9 a.m. I, on behalf of the resident of Samata Tulsinagar village, inform you that the above mentioned two persons were carrying suspected banned beef in bags on a bicycle along with the road of Tulsinagar village for the purpose of illegal sale, lordship. That was the allegation, lordship. Today's lordship 53 days, lordship. Mandatory period 60 days, lordship. Ordered hardship. Why, lordship? FI self-stated the suspected meat, lordship.
Yes.
They were apprehended when they selling this item. Twice they were in possession of this 30 kg. Apart from that, 5(1) of the Assam Cattle Preservation, according to which within the 5 kilometers that area. I have flag mark, Lord.
How many days in custody now?
53 days, lordship, today, lordship. Arrested on 12/2/2026, lordship.
Third learned counsel for the petitioner and learned additional people. So and so. Petitioner. He was involved in the of at Samata Tulsinagar. The act of $50,000 to 70.
It is your lordship. Lordship. NDPS is lordship commercial quantity. As on today, I am behind about 51 days, lordship. I am the license holder, lordship, in this case. The controversy was seized from my pharmacy, lordship. The list in page number 37, lordship. This is place from where Caesar Akula Pharmacy, lordship. My pharmacy, lordship. The controversy 860 codeine phosphate and triprodine hydrochloride syrups, brand name Coughs Linctus triprodine hydrochloride and codeine phosphate syrup, brand name Novogold, lordship. Novogold is a established medicine, Lordship.
You are also licensed to sell ganja.
No, Lordship, I'll come that on that, Lordship. This is not ganja, Lordship. This is a cough syrup, Lordship. For this, Lordship, on notification is there, Lordship. Notification is annexal, Lordship. E, Lordship. It starts from 41, page number 41, Lordship.
Yes, what?
The relevant entry, that is page number 43, entry 35, Lordship. And this case, Lordship, methyl morphine commonly known as codeine, and ethyl morphine and their salts, including dianine, all dilutions and preparations except those which are compounded with one or more other ingredients.
Yes, PP, was he able to produce any license or anything?
I have the license, Lordship.
Licenses, even the licenses they are, my lord. He is not authorized to sell to anybody, my lord, without prescription, my lord. And lordship may kindly come to the FIR, my lord.
Without
Let me complete this. May kindly see, my lord. First, my lord, one Rohimuddin Loskar was apprehended, my lord. Then from the possession of Rohimuddin, my lord, contraband was recovered, my lord. Then, my lord, he has implicated one Rontu Ali, my lord. When the Rohim was interrogated, he has implicated Ali, that from him, my lord, I used contraband, my lord. Then Rontu Ali was arrested, my lord. Then he was interrogated. Then he has implicated this Manik Singha, my lord. And from his, my lord, medical store, really covered by Mohit Agarwala case, no. The basis of co-accused statement, my lord, his pharmacy was searched and recovered, my lord. Assuming, my lord, he has a valid license, my lord. But without the license, my lord, how can he sell, my lord, this kind of contraband, my lord? 1 and 2 bottles, my lord. The case is pending, my lord, to collect the official report, my lord. Let the official report come.
Lordship.
And lordship may kindly peruse the page number 55, my lord, of bail application. 55, condition of license, my lord, clause number 3.2, my lord. No sale of any drug shall be made for purpose of resale to a person not holding the requisite license to sell, stock or exhibit for sale or distribute the drug provided that the condition shall not apply to the sale of any drug to any officer authorized purchasing on behalf of government, a hospital, medical education, research institution, or a registered medical practitioner for the purpose of supply to his patients. Any manufacturer of hydrogenated vegetable oils, beverages, confectionery, and other non-medical products where such drugs are required for processing this product.
Lordship, accused number 1 and 2, Lordship, there is Rohimuddin Lashkar and Rontu Ali. The seizure list I have also annexed, Lordship. The seizure list will show, Lordship. That is in, starts from page number 29, Lordship. The list, Lordship. Rontu Ali, Lordship. From Rontu Ali, some cough syrup has been seized, Lordship. That is, Lordship,
That is the mobile phone.
Lordship, mobile phone. Next page is the Lordship. That is mobile phone, and another page 33, Lordship. And Lordship, the cough syrup brand name not been mentioned. From my possession, Lordship, the brand name was Novogold cough syrup, Lordship. That is different, and another from Rohimuddin.
Continue.
Lordship. Yes, sir. Lordship.
Please, your lordship. Paragraph 14 of the order and irreplaceable. And
Yes, what is this?
page number 15, my lord. This is the order passed by the learned session judge, my lord, special judge Gauhati, my lord. We've given a copy.
Page number?
Page number 15, lordship. Paragraph 14. Further, that during the pendency of the connected criminal appeal, the applicant is allowed to go on bail and furnishing a bail bond of rupees so and so with one suit of subject to the. No, the name of the accused are two accused. Name has not been mentioned, my lord. That correction we require, lord. Our prayer for bail was rejected, my lord. By the session judge, that order we have furnished, my lord. The correction that we have mentioned is at page number number 7, my lord. Page 7 we have mentioned. Page 7, my lord, of the petition, my lord.
There are two applicants.
There are two applicants, my lord. Husband and wife, my lord. The order that we have furnished, my lord, now is the order of the session judge, my lord. Page 2 of the order, if lordship takes up, my lord. Page 3 of the order, lordship. It is stated in para 14 of the aforesaid order dated so and so passed by the Honorable Gauhati High Court in criminal appeal number so and so. Further, during the pendency of the connected criminal appeal, the applicant is allowed to go on bail and furnishing of so and so. The order has been quoted. Two applicants have preferred criminal appeal number before the Honorable Gauhati High Court. In para 14, it has been stated the applicant is allowed to go on bail and furnishing a bond of 50,000 with one surety of the likeness to satisfaction. There are two applicants appellant in here in this case, and no specific order has been passed by the Honorable High Court to accept the bail bond in which favor of the accused appellant. Hence, in view of the petitioner so and so is to clarify which of the accused appellant has been granted bail by the Honorable High Court. Which, Lord.
The sentence has been suspended.
Then
Then
suspend.
what is the question of specifying which one?
Lord. We tried to impress upon as told by the local council there, my lord. Or the order has been passed, there is no power of review also. We have to approach here, my lord.
Applicant. Correction of the in IA. Paragraph. Aforesaid order. That the and allowed to go on bail. Applicants stroke. clarified that. Granted bail. Both. As, okay, as. Part of the order date 010426. First in.
I moved it.
But in regard to item number 28, I forgot to mention about the continuation of the interim period. That may be continued, Your Lordship. Item 28. Highly appraised.
Wait, please, your lordship. Lordship, this is a regular bill. So far, my understanding, lordship, statutory period is over, lordship. Today, 96 days in jail custody, lordship. And the last order, lordship, will kindly peruse the last order, lordship. No case of POXO against these two petitioners, lordship.
Has it submitted?
My lord, that instruction not yet received. After some time, just
Lordship, of the rejection order that is on page 20, lordship, kindly peruse that rejection order.
Right, he'll get the instructions right now.
Wait, please, your lordship. Lordship, in this case, what happened, lordship? This petitioner, although named in the FIR, lordship, by one co-accused person, lordship, it is a case, lordship. Preparation for committing Gauhati, lordship, on the state. Wait, please, your lordship. Lordship, this is a regular bail, lordship. 97 days today, but lordship, kindly come to the page 28, lordship, the order, lordship. He was arrested, lordship, in the FIR, his name was there, lordship. Subsequently, charge sheet has been shown, lordship, submitted. And NBW was issued, lordship. Now, when he on the strength of NBW, he was arrested, lordship. The rejection of bail order, lordship, will find on page 28, lordship.
Yes.
Bottom portion, lordship, it is further revealed that the accused Saddam Ali has never appeared before this court during the trial, remain absconding during the investigation. As such, there is a as such, there are chance of his absconding, hence bail petition is rejected, lordship. Some person, lordship, who has committed this offense, lordship, they were arrested from the spot, lordship. Moreover, there are several person is there, lordship, 2 person. Other 2 person, lordship, granted bail by the court below, lordship.
They appeared.
they appear earlier. Now, in this case, 6 persons were there they are going to Gauhati, some, this, the signal, they don't stop. Where, some firing also there, 5 rounds of AK-47 ammunition. 9 mm ammunition were seized. These persons and other fled away, even them succeed. They have not appeared all along, 2021 case. Now, when NBW issued this appearance and quote below, rightly passed the order, since they are not appeared and the COIC is also not appeared.
COIC is 2 of the COIC is granted bail. That is reflected. That is reflected in order 28.
In appearance stage, still. One of them fired on police, police on retaliate, police to save friends, police also.
On the spot. On the spot, 3 person was arrested, Lordship. That is reflected in the FIR, Lordship. FIR that is on page 16 onwards.
FIR 6 persons were there.
Page 20, Lordship, bottom part, Lordship. These petitioners' names were mentioned by one Rabiul Hussain, Lordship.
Is number 3 in the FIR.
And Rabiul Hussain is, Lordship, granted bail, Lordship. Page 28 reflect his name, Lordship. Page 27, Lordship, he was present, is shown. Biju Ahmed absent with stay. Any stringent condition, Lordship, you will abide by the condition, Lordship, and will cooperate with the trial, Lordship. Because it is uncertain when other person will be arrested, Lordship, and till they are absconded, Lordship.
Arrested on
29/12/25. Then 97 days.
What is his involvement?
He was there in the
Vehicle.
He fled, yes, in the vehicle. He, along with other 2 others, fled away. 3 persons caught by the police. AK-47 ammunition and 9 mm.
Not from this petitioner, Lordship.
He fled away.
In the vehicle.
That vehicle, Lordship, since Lordship is Lordship on 97 days in jail custody, Lordship, and it is uncertain regarding other regarding arrest of other.
He will never come back.
Some still absconding,
From 2 person only appear. Other 3, another 3 person is absent.
Release you, then another
Any
will be found, then you will not be found.
Every 50,
This
Lordship,
will keep on.
Lordship, now Lordship, it is a session trial, Lordship, it's not split up, Lordship. Till that, Lordship, will cooperate, Lordship, any stringent condition, Lordship. In violation of any condition, Lordship, his bail may be rejected, Lordship.
Who has been granted bail?
Lordship, that is reflected on page 28, Lordship. Prabhu and Biju are absent with step petition.
Prabhu and Biju, these persons were arrested on the first day, my lord.
Have been granted default bail also. Who knows?
Saddam, more to Saddam.
It can still be split up.
Yes, can be split up.
File application for splitting up.
Since Lordship, I am in jail, Lordship.
Yes, you have to be in jail.
Yeah,
You have to be in jail.
Because Lordship isn't shown as an absconder, Lordship. That opportunity can be given to Lordship contest the trial, Lordship. Person even outside Lordship, he's contest the case better than Lordship remain in jail, Lordship. Because other two persons are already granted bail, Lordship.
Very well. Will do what you cannot do.
The recovery from them, Lordship. It's a recovery from them. Not from anything recovered from this present petition.
They were
Only the
arrested
statement of the one of the co-accused.
They were
That much
arrested
is
in
against them, Lordship.
2021. They were arrested 2021. And he, malad, fine.
That cannot, but the ground of arrest, Lordship, is not, that is, cannot be, Lordship. It is uncertain, Lordship, when the other person will be arrested, Lordship.
Not necessary. Trial can proceed.
Can
without
it be,
that.
Lordship, detained in for indefinite period, Lordship? Because
No,
his
trial can proceed.
trial is process still appearance stage, Lordship. It is not
Why should
split
it
up,
be at
Lordship.
appearance stage? It can be split up.
But it is not done, Lordship.
For you to take care of there.
Until unless, Lordship, there is a Lordship approach the court for splitting up of this trial, Lordship. That was not done, Lordship. TCR is there, Lordship.
Is there? What order is there?
That I have not seen, Lordship. There, TCR is there, Lordship. That's right.
You are referring to some order of.
No, Lordship. I am not referring anyone.
What are we supposed to see in the TCR now?
They could have approached, Lordship, for splitting up this trial, Lordship.
Yes.
They have not done it.
You have to do it.
Now, Lordship, I have to come out from the jail first.
Why should you come out from the jail? You are
Because, Lordship, I have
represented.
to arrange my defense first, Lordship.
Yes.
I have to arrange my defense first, then, Lordship.
Oh,
I will go
everybody.
for the Lordship.
You mean all the persons who are in jail are not represented
Lordship.
by defense? Trial
That
is going on
but
for
since-
years.
But, Lordship, since that, Lordship,
But what are the advocates there for?
other Lordship, accuser, Lordship, getting that privilege of bail, Lordship.
They are getting the privilege of bail because they have appeared.
Now, they have happened, they were arrested on the spot, Lordship. And I have also, Lordship, arrested on the strength of the NBW, Lordship.
Not have happened if you had appeared earlier. Delayed the trial by 5 years.
Stringent condition, Lordship,
No. The charge sheet was filed in the year. So and so. No? The petitioner is under arrested on the strength of NBWA on
NVW issued lordship on
No, when was he arrested?
arrested lordship, it is
29/12/2020.
29. Yes, 29/12.
25. The allegations against the petitioner are extremely serious. Here's that petitioner absconded for several years, apprehended the basis of NBW. The learned trial court rejected the prayer for bail. The present petition. Because of the cost of further abscondence, bail is granted to him. Appeared before the court earlier. Reason to given. Hence, the prayer for bail stands.
At this stage, lordship. Tally of it.
Oh, which is bail application, lordship. I am a non-compliance of under section 47 of BNSS. Page 67. The type copies. Page 67. The case is non-bailable, forwarded to the court. You may submit petition before the honorable court of your bail. And in 48 was not turned. I am in judicial custody for 1 year, 8 months, 3 days. Trial is yet not initiated, lordship. Not comments. Charges not framed. During this 1 year, 8 months, and final complaint has been submitted on 29/1/2024. I have annexed the order that is on page.
There is some absconder.
Yes. One is absconder. Final complaint has been submitted, showing one is as abscond. But it is submitted on 29/1/2025. Page 66. Page 66 is the order. And I'm languishing. We have
48 is not there.
not there, not furnished.
Yes.
On 47. Though the section 47. It gives the details option. I don't know, like not.
The record. You have phlegmatis. Said. Miss
Surjit Singh.
it.
Yes, yes.
About 48.
There's I 47 and 40. They're not not furnished.
But is that a ground in your petition? Seconded ground in your petition.
Yes, there's.
You have to answer it.
They must specific in 47, 48. Lots of I have. Yes, five onwards. Yes. In my petition, paragraph 6, 7, 8, 9, 10.
But
Lordship.
8 is there.
Lordship, no 48. 48. I made statement, Lordship. I find yes, Lordship. This page 11, Lordship. Page 11, I have furnished that. So it is start on by place 10, paragraph 5. In my petition, bail petition. Page 10, paragraph 5. Otherwise, it's basically on 5.
Does it say that line?
Further, petitioner begs to state that though the arresting authority has furnished the notices, but they have not mentioned any detailed grounds of arrest in the notices furnished to the petitioner as required to mention and communicate the same in writing to the petitioner under section 47 of BNSS 2023. It is further stated that the contents of the notices under section 47 BNSS 2023, which was furnished to the petitioner is, you are hereby informed that you are arrested in connection with the above reference case and the case is non-bailable, so you are forwarded to the court. You must submit petition before the honorable court for your bail. Lordship, therefore, from the plain reading of the said notice under section 47 BNSS, it appears that there are no detailed grounds of arrest in the said notice. They have also not followed the provisions laid down under section 48 of the BNSS 2023, which is a violation of the article 22(1), followed by the Prohibitions and Vihan Kumar.
Is not there. Requirement of 48 in writing is only from Vihan Kumar. When was the date of arrest?
3/8/2024. It
This is
one-
before Vihan Kumar. You have before Vihan Kumar.
20, it is after.
Tripurka Esther does not deal with 48. 7 only.
So in Vancouver, Probable Castle Lordship, it is part 21, it is the mere fact that the charge sheet has been filed in the matter would not validate the illegality and unconstitutionality committed at the time of arresting of the accused person. The Probable Castle.
The unconstitutionality. Is the unconstitutionality here?
Not mentioning the grounds of arrest.
Which article of the Constitution has been violated?
Lordship, in paragraph 48.
No,
Regarding
you said unconstitutionality. So which part of the Constitution has been violated?
Lordship, I'm reading the citation of the Probable Cause as stated by the Supreme Court of India.
Yes, so you have to apply it to the facts of your case.
Yes, Lordship. It is paragraph 48, Lordship, the relevant person, Lordship. The reasons would commonly apply to any person arrested on charge of crime, whereas the grounds of arrest would be required to contain all such details in hand of the investigating officer, which necessitated the arrest of the accused. Simultaneously, the grounds of arrest informed in writing must convey to the arrested accused all basic facts on which he was being arrested, so as to provide him an opportunity of defending him. Bail, Lordship.
So you are on 47.
Yes, sir. So 47, but 48 also.
Plus 48. Which constitutional provision covers 48? Does 22 speak about informing the relatives?
Condition of Article 22, 1 and 21.
Read Article 22.
In 22, Lordship, it included in Part 3 of the Constitution under the heading of fundamental rights. Thus, it is fundamental right of every person arrested and detained in custody to be informed of the grounds of arrest as soon as possible.
Yes, so 47. We have not decided whether 47 has been complied or not. But since you are on 48 also, that is the point we are trying to clear first. So how has 48 been violated? Indication of grounds of arrest in writing has come for the first time in Vihan Kumar. And not based on any constitutional right. All right. Anything else?
There is a violation of the fairness, Lordship. Our Lordships, I am in judicial custody for more 1 year, 8 months, 3 days, Lordship. Till that charges not framed.
All right, we'll see.
Please, your lordship. On last occasion, lordship was pleased to call for press PCR regarding the framing of charges, lordship. And the charges were framed, lordship.
Charges are framed on 2426, my lord. Section 21B and 29.
Are behind the bar since last 76 days, lordship. Earlier criminal antecedent.
Next date is 19/6/26 for evidence. That 2-3 pages, my lord, let us come, my lord. The TCR, my lord, 2-3 pages, my lord.
Okay, it's intermediate quantity.
Intermediate. sir.
But
Is
let
that
it
right?
counsel for the pit. This is an application on allegations. Any petitioners? No.
Petitioners, lordship.
Petitioners. While they were traveling by Nakumari Vivek Express. On from of Gauhati railway station. Investigation of charges under sections
Lordship, 21B and 29, lordship.
1B, small b, within bracket. Verse 4.
76 days, lordship.
Fact that the trial is bail is allowed.
Obliged, lordship.
Regularly participate in the trial.
This case, when earlier it was matter was came before lordship, lordship was on the seizure list, lordship. On the basis of a co-accused statement, the present petitioner was arrested, lordship. And from that petitioner, page number 33, from that co-accused, lordship, page number 33, lordship, lordship will find the seizure list where Procroft T and Broncroft C, this cough syrup was seized, lordship. And later on, from the possession of lordship, present petitioner who is a valid license holder, lordship, from his possession, lordship, Nobogold, lordship, has been seized, lordship. Page number 37, lordship.
But is it commercial quantity?
May I read from the NDPS Act, Lordship? It will clarify, Lordship. In NDPS Act, Lordship, definition part, Lordship, in section 2, Lordship, the specific para, but does not include any narcotic substance and preparation which the central government may having regard to the available information as to its nature or to a decision by any under any international convention by notification in the official gazette declared not to be manufactured drug. Regarding that, Lordship, there is an official notification, Lordship. On page number 41, we have annexed, Lordship. Page from it start from page 41. The specific is on page 43, Lordship. Entry 35, Lordship. Can I read from it, Lordship?
Yes.
Lordship, methyl morphine, commonly known as codeine. This is the substance, Lordship. And ethyl morphine and their salts, including dionyne, all dilutions and preparation except those which are compounded with one or more other ingredient and containing not more than 100 milligrams of the drugs per doses unit with a concentration of more than 2.5% in undivided preparation which have been established in therapeutic practice. Lordship, in this regard, it has to be more than 2.5% come under manufactured drug, Lordship. And in the Drugs and Cosmetic Act, it is specifically in the Schedule H, Drugs and Cosmetic Act, it is been specifically mentioned that the codeine, the substance, falls under the prescribed drugs, Lordship.
What was found on you? Dionyne. What?
Lordship, the codeine phosphate, Lordship, and the cough syrup name is Novogold, Lordship.
So it's codeine.
Codeine, Lordship.
It's a manufactured drug.
No, Lordship. If the percentage is below 2.5%, it does
How
not.
do we know that?
In that regard, Lordship, the forensic will clarify. But there is one more aspect, Lordship. If I continue, Lordship, the prosecution side has stated that the co-accused on the basis of a co-accused statement, the present petitioner was arrested. But if Lordship goes to the
Maybe arrested on the basis of a statement, they went to you, but it was recovered from your possession as
it
well.
was recovered in my store.
Yes, your
in
store.
my pharmacy, Lordship.
Yeah.
And for which I have a valid license, Lordship. And I have the bills also. Lordship, I have annexed the bills also, Lordship. Lordship will find on page 58. In my earlier pages, I have annexed the license which has been continued and which is valid up to 2027. I have annexed, and the bills also, Lordship, I have annexed from page number 60, 63 and 64, Lordship. These are the medicines which are purchased by the present petitioner in respect of the license that has been provided under Drugs and Cosmetic Act, Lordship. And in the Drugs and Cosmetic Act, Lordship, it is specifically mentioned, Lordship, section 65, condition of license. The supply of drugs on a prescription of registered medical practitioner shall be recorded at the time of supply in prescription register specially maintained for the purpose, and the serial number of entry in the register shall be entered on the prescription. Lordship, in this regard, as per the co-accused, if we go by the co-accused statement also, Lordship, no registered has been seized from my possession in my seizure list, Lordship, to prove the allegation, Lordship. Lordship goes to the seizure
Will you
list,
maintain a register of illegal sale?
Lordship, but even if Lordship registered was, nothing was seized from my possession, Lordship. No registered was seized to prove the allegation, Lordship. And codeine has been specified in the Schedule H of Drugs and Cosmetic Act that and Lordship, I am relying on a judgment, Lordship, on Madhya Pradesh High Court, Lordship, where the court has taken view that This court does not differ from the views adopted earlier by this court in the case referred above. It is held that the prosecution may consider and take appropriate action if any provision of Drugs and Cosmetic Act has been violated. But so far, the provision of section 21 and 22 of NDPS Act is concerned in crime number so-and-so registered by police so-and-so is therefore quashed, Lordship. This case, only Lordship, the similar facts, Lordship, the codeine was seized, Lordship, and later on, if anything, if there is any violation, it will come under Drugs and Cosmetic Act, Lordship. Various judgments of different High Court, Lordship, have. And in the inventory also, Lordship, specifically mentioned, Lordship, codeine, Lordship, the substance. Anita Gupta judgment, Lordship. According to Drugs and Cosmetic Act, if anyone is there to take cognizance, is the Inspector of Drugs Control, Lordship. Rajendra Bandil and alias Raju Bandil versus State of MP. Similar view was taken, Lordship.
Yes, maybe. FSL report come, my lord, whether this come under the act or not, my lord. But the NDPS Act, my lord, it also coded come as a banned drugs, my lord. When he is licensed to sell, my lord, he cannot sell those drugs to those my lord, to without any license, without any prescription to.
But is there any material to show that he has done that?
So, my lord, he has been arrested on the basis of, my lord, the 3 accused persons, my lord. And the first accused person was arrested, my lord, from his possession, 258 bottles were recovered, my lord. Thereafter, my lord, the accused person was interrogated. Then he has implicated. And from his possession, my lord, 860 bottles were recovered, my lord. Without the FSL report, my lord, he cannot say, my lord, these are not, my lord, the banned drugs, my lord. He can sell it, my lord.
The drugs rule, Lordship, this categorically mentioned.
Let me submit it. But, and what is his license say, my lord? We will come to page number 54, my lord. Following categories of drugs specified in Schedule C and C1, my lord. Except, my lord, Schedule X drug, my lord. Page number 54, my lord.
What is Schedule X?
My lord, the Schedule X drugs, my lord, there are some, my lord, drugs mentioned in the, my lord, in the, my lord, of the, my lord, Cosmetic Act, my lord. The FSL report come, my lord. Without the FSL report, my lord, because the codeine phosphate cough syrup, my lord.
If I may, Lordship, the codeine falls under prescription drugs and it is mentioned in the Drug Rule 1945, Lordship, in the Drugs and Cosmetic Act. Lordship, may I read, Lordship, specific, Lordship, Schedule H, prescription drug, not to be sold by retail without the prescription of registered medical practitioner. If it contains drug substance specified in Schedule 8 and comes with the purview of narcotic drugs and psychotropic substance, be labeled with symbol NRX. The symbol has to be there, Lordship. And it is there, Lordship. It is prescription drug, Lordship. The codeine comes under prescription drug, Lordship. Schedule H, Lordship. I am a bona fide person having a drug license, Lordship, having all the bills purchasing of the said has been seized from my possession, Lordship. Next, all the bills, Lordship, regarding that. And any person who is having a pharmacy, Lordship.
Other than the statement of co-accused, is there any material to show that the drugs recovered from the co-accused are from this pharmacy?
My lord, he has implicated, my lord, the co-accused person who has been arrested, my lord. He has implicated that I have procured the drugs, my lord, from this pharmacy, my lord. That is why, my lord, police have, my lord, arrested him and charged his, my lord, pharmacy, my lord. But, my lord, contraband, my lord. It is not that, my lord, but nobody has, my lord, implicated him, but police during investigation recovered. That would have been another case, my lord. First arrested, then, my lord, he was interrogated, my lord, then he is implicated. It's squarely covered by Mohit Agarwala case, my lord. The basis of co-accused statement, my lord, recovery has been made, my lord. Now it is a, my lord,
What does Mohit Agarwala say?
Agarwala, my lord, I can rely on, but today the hard copy is not available with me, my lord. Because Mohit Agarwala case also was same, my lord. He was arrested, nothing was recovered from him, my lord. But on the basis of his statement, my lord, police searched the, my lord, godown of the, my lord, another accused person, my lord, from where, my lord, several quantity of, huge quantity of, my lord,
the facts and circumstances of the case, but in this case, Lordship, I have a license.
This is a, my lord, investigation stage, my lord. He is not coming from quashing of the FIR, my lord. So let us produce the, my lord, FSL report, my lord.
And can you do that?
Time we have, my lord, it will not be possible, my lord. After vacation, my lord.
That regard also, regarding the I have my section 65 of Drug Rule Act, Lordship, where the petitioner has to maintain a register. In that case also, if my premises has been, the investigating agency has gone to my premises, they had not seized any registered. They had not seized any registered or any, Lordship, entry book to prove the allegation, Lordship.
For that, my lord, I'll take instruction, my lord. Investigation is there, my lord. This is the first time, my lord, the CD was called for, my lord.
And I have categorically, Lordship, I have annexed the seizure list. It is not mentioned. The codeine falls under Schedule H, Lordship. In the Drugs Rule Act, it is specific, Lordship, the prescribed drugs, Lordship. It is. On prescription, the
Depends on the
phosphate is a
quantity
drug, my lord.
also.
Then phosphate is a drug, my lord. It is clearly mentioned in the my lord,
Yes.
NDPS Act, my lord. My learned friend is submitting, my lord, I don't understand.
There are
FSL
hundreds of
report-
cases involving codeine and in under
Cough syrup, my lord.
NDPS.
Cough syrup contains codeine, my lord. Everybody knows.
my understanding it falls under H, which is prescribed.
Or under 2.5% or whatever. Depend on the number of bottles, quantity.
That, my lord, harassing is clear, my lord.
Harassing judgment has been referred while the petitioner was forwarded, but in the Lordship inventory also the percentage is not mentioned, Lordship. Specific percentage may come, Lordship, if it is as it is sent for FSL, Lordship. In some cases, we do not find the percentage, Lordship. Because the gazette notification is there, Lordship, and gazette notification is clear that it has to be below 2.5%, Lordship.
Convinced about that because hundreds of bottles of codeine are seized. Bottle may have less than that percentage, but still would not that amount to violation of the NDPS Act because it is mentioned in the schedule also, notification regarding small quantity. Not there. Codeine is there. Ultimately, if what is the suppose commercial quantity of codeine is X, then from the number of bottles seized from you, that X is crossed. Then why would it not come under NDPS Act?
He is a
We
bona
cannot
fide
always
license holder, Lordship.
We may not go by percentage. It has to do with the quantity.
10 bottles become, my lord, commercial quantity, my lord.
Yes.
When 10 bottles, my lord, says it has become commercial, my lord. In this case, my lord, 860 bottles, my lord.
Okay, we have to go deeply into this. So you produce the FSL reopening.
Specific percentage of the drugs, Lordship. It's specific percentage.
Clear from the FSL report.
A specific instruction may be sought, Lordship.
I'd learned counsel for the state report would be necessary. Private receipt of FSL the matter again on so and
28, my lord.
That the FSL now, Directorate of Forensics. The
Concentration
of phosphate right, if any. Get this to the official.
Done the case diary, my lord. The case therein call for opposite.
Ready to be resubmitted along with.
Deeply obliged, Bench. I apologize, Lordship. Miss was there in my order dated 23/70.
'Yes.
Second paragraph.
You are who? You
My
are
name is Samiruddin.
Samiruddin.
Samiruddin. Second paragraph. The petitioner for bail of the accused Shamim Ahmed and petition was for this Shamim
Yes.
Ahmed and
Yes.
now this case, Lordship, they have taken the ground of non-furnishing the ground 7. My lord, may kindly come to the relevant portion of this order, that is number 73.
Yes, 73.
73, my lord. Second paragraph. Thus, it appears from the decision of the Honorable Supreme Court and the mood of in this particular case, I found that Ziaur, whereas Shamim Ahmed put that Shamim Ahmed understands English. As such, I am of the thus considering every so Lordship, Ziaur Rahman and Shamim Ahmed, them, nothing was recovered. Kindly come to page number 7. Heard the learned counsel for and 41 filed by Anwara Begum and for the bail of the accused person Yasuddin, Samiruddin, Abdul Khalik and Shamim Ahmed. For my lord, may kindly come to the relevant page number 81. If this bail petition was for the petition along with 4 others.
Samiruddin, so you were there.
Yes.
Page?
Page number 81, my lord. Second paragraph. Cognizant that the plus clarity on oblique above shall govern Twelve 6/2000 person the arresting thus I find course in the submission of the learned
that the written ground is November 6 petition in this order. I don't Bihan Kumar. Page number 90. What? 90. Issued under section 47. Miruddin, that is the petitioner. Next page. Copy receipt. The signature of the petition was in Bengal and the 48 next was supplied to the wife of the petitioner. Entire grounds of arrest were, and she put her last place, my lord. Bengali. And another ground that my lord was released on bail.
This 48, you have given your thumb impression. That means you cannot sign. You're illiterate.
Wife of the present petition.
So, what difference does it make if it is given in English or Bengali or Hindi or any other language? You cannot read anyway. Then
But lordship, in the last portion, lordship, it has clearly been mentioned that the grounds of arrest and reasons of arrest have duly communicated to me in a language, namely Bengali. But where is that grounds of arrest in Bengali?
they have furnished, but if they fully communicated means what? Maybe oral also.
Specific, my lord, arresting officer in a language known by me, namely Bengali, my lord. That, my lord, that interpretation has been made in English, my lord. That Gandhra Vedas has been made to understand to the, my lord, members of the.
That is what it
in
means. It
Bengali
must have
language.
been done in Bengali only.
Was made to understand in Bengali language, my lord. Only, my lord, this portion, my lord, signature of the informed person, this portion, my lord, it is written in English, my lord.
The grounds of arrest. The arrested person. Here, Somiru, it is specifically mentioned that I know Bengali language. Also stated that grounds of arrest were furnished Bengali. But lordship, perusal of the grounds of arrest, it shows that lordship. Now, my lord may take up this order date 2026. This is lordship in respect of request Shamim Ahmed, from whom also lordship page number 2. Finds that no contrabands were seized from the vehicle where the petitioner was found.
Does it have to do with furnishing of grounds of arrest?
Another ground I am taking, lordship, the possession of the petitioner, nothing was recovered. Everything was recovered from 2 persons and they were in another vehicle. And the petitioner along with 2 other persons, they were in another vehicle.
You are the escort or the pilot?
No, my lord. Even if
if lordship goes by the FIR.
FIR, yes.
My lord, 2 persons were arrested, 2 persons were intercepted, my lord. Then, my lord, their vehicle was seized. Then, my lord, contraband was recovered, my lord. Then, my lord, they said that they have come to, my lord, supply this, that, my lord, 2-3%, my lord, they are coming, my lord. And on the spot, my lord, they arrived. And on the spot, they were arrested on the same day, my lord. The spot, my lord. It is not that, my lord, on the basis of quick statement during investigation, these 3 persons were arrested. These 3 persons were coming in a Wagoner vehicle, my lord, and they were arrested on the same spot, my lord, where the other accused persons were arrested from was recovered, my lord.
Have been arrested on the spot, but nothing was recovered from them.
Necessary, my lord. In case of commercial quantity, my lord, recovery is not signed on, my lord. So they have come to receive the contraband, my lord. And on the basis of quick statement, my lord, on the same place, my lord.
And they have come to receive, that is based on co-accused statement.
Yes, my lord, but on the same spot, my lord. The same spot, my lord. Now it is the search case, my lord. So we'll have to go, my lord, this bail application on merit, my lord. And regarding the ground of arrest, my lord, if this portion is not there, my lord, she has only put her thumb impression, my lord, then, my lord, lordship may, my lord, presume that, my lord, without understanding, my lord, she has put the signature, has put her thumb impression, my lord. Has put her thumb impression by stating that, my lord, that the ground of arrest, my lord, it was make me understand in Bengali language, my lord. And after having understood, my lord, I have put my signature. I have comprehended the said grounds of reasons without any ambiguity or confusion, my lord. Now, while filing the bail application, my lord, they have come with another ground, my lord, that no, I do not know any, I do not understand any, my lord, language. I am illiterate. So, my lord, this ground of arrest is not genuine, my lord. This is, my lord, for mere formality, my lord. The family members of the accused person, my lord, that, my lord, this person is arrested in connection with this case, having, my lord, found this much of contraband, my lord. So this is the information, my lord, furnished to you, showing that, my lord, the accused person has been arrested, my lord. This is a mere formality, my lord.
All right.
Grounds of arrest is concerned, lordship. Five seven. And lordship, so far as accused statement what has been recovered from my possession is concerned, even in the charge sheet also, page number 51, they, while submitting the charge sheet, it has clearly been mentioned by the investigating officer that during on the spot interrogation, both the accused person, Abdul Khalik and Giyasuddin, disclosed that 3 persons were coming, meaning thereby, lordship, we were arrested only on the basis of the co-accused statement. And point number 3, the seized tablets recovered from the possession of the accused Abdul Khalik and Giyasuddin, clearly mentioned in the charge sheet.
Where in the
also.
charge sheet?
Charge sheet page number 51, my lord. It starts from page number 36.
All right, we'll see.
May I furnish this copy, lord?
Your lordship, there is bail application, allegations under cheating and criminal breach of trust. What happened, my lord? I am working under the second-hand car dealer, namely Aditya Motors. Now, my lord, this informant admittedly sold the vehicle, and I, being the mediator between the Aditya Motor and the informant, helped the informant to commence the transaction. And thereafter, my lord, some installments were not paid by the purchaser, that is Rajiv Gogoi. Now, my lord, in this case, in the FIR, that is page number 15, informant admitted that there is a written agreement between them. There are breach of some conditions of the agreement. There is criminal intention behind that. In second page also, my lord, informant admitted that by contravening the terms and conditions of the written agreement. So in that way, there is no criminality. And your lordship, so if you follow the judgment until judgment, it's a category A offense, my lord. Maximum punishment is 3 years and 5 years. So in that way, as per paragraph 63, the discretion of this honorable court be favor of the accused. Yes, my lord, there is no need of custodial interrogation. And I have also annexed my medical documents. Due to heavy loss sustained earlier, I was suffering from mental stress and depression, and I have undergoing treatment for mental disorder at Tezpur Medical College. Since 2024.
I have an agreement, lordship. It is true, there is an agreement between the husband of the informant and there are some terms and conditions regarding EMI, and it has been clearly stated that the vehicle has not been sold. After it will be considered as sold only after the payment has been given. But whatsoever, lordship, but it has been sold according to this person, lordship, and moreover, the vehicle has not been recovered yet, lordship. Where the vehicle has been, it has not been come up where it was, lordship. It is. So it is because of that custodial interrogation is necessary, lordship.
Not reply. I want to submit one thing that from the FIR itself, informant came to know that the vehicle is in the possession of one Rajiv Gogoi. Mobile number is also there, my lord.
But he cannot.
So I am the middleman, my lord. And my lord, I am not going into the deep, but when there are installments pending, informant also is not legally allowed to enter into agreement.
What I want to understand.
In that way, he is also violating the law.
But in the agreement itself, it is stated that it has not been sold. On what authority he has sold, lordship? That is a clear lordship. Ingredients are there.
Agreement is about what? Why would he pay the installments? For what reason?
Lordship, it is stated that agreement is regarding that these two persons, and it is regarding that this person, the accused person, lordship, will pay the amount, and on that, if the payment is paid, lordship, to the financer, then he will be sold this vehicle, lordship. But as he also knows that, lordship, it has not been paid, but it has been sold.
We come to para 6, my lord.
Let me finish first. Let me finish. If he has a clear intention or he had a good intention, lordship, he should have provide the lordship the vehicle. Why he cannot say that? Where he has stated that he has sold it to one Raji. That person is also untraceable, lordship. So at this moment, lordship, I am not on that fact, lordship, whether it is a intentional or what is there. But at first, his vehicle should be traced, lordship.
But
otherwise, it is a clearly breach of trust, lordship.
Oh, my lord, first of all,
misappropriation also comes.
Lordship.
My lord, I have clearly stated the entire facts in para 6, my lord. Actually, that vehicle was dealt by one Aditya Motors. Kindly come to para 6, my lord. How I was in the picture, as per the instruction of one Jayantonath, as he was not available in that office during that relevant period of time, during the transaction, he signed in the agreement. I am also having some mental issue, my lord. So, lordship will decide. It's a category A offense. I will fully cooperate with the investigation, my lord. I am ready to appear before the even after every 15 days, my lord. There is no issue on that.
On the top of it, lordship, I want to also focus on the FIR. In the last few lines, lordship, few paragraph, it is also stated that the accused person is a great cheater, and he with ill motive have taken the vehicle from us, executing the agreement and he has sold it to other person also.
And kindly come down below. Contravention of the terms and conditions written. So
otherwise,
when there is breach of some condition of the agreement, written agreement, my lord, the informant has also take recourse of the civil court also. that remedy was also open. So in all possibility, my lord, I am ready to cooperate with the investigating agent.
I have a remedy in civil law, but if
My lord,
criminality is revealed by the FIR, then how can you simply escape by saying it's a civil case?
This is one of my submission, my lord. This is a category A offense. Now,
Fact is that you have taken the vehicle and have sold it.
Aditya Motors, my lord, I have stated,
The
I was
agreement is
working
not-
as an,
But in the agreement, what I have, it is nothing about the Aditya builder, Lordship.
there, my lord, but I have stated Aditya Motors. Now,
I have stated many things, but it is not there in the document.
no, my lord, it is not there. I have stated it, that how I was working
It's
after
not a fit case for
sustaining heavy loss, my lord. So I may be protected, my lord. I am ready to cooperate with the investigating agency. Considering my medical illness, my lord. The Tezpur Medical College document, my lord, abnormal behavior and all this written.
Vehicle. Installments. Petitioner. Owner. Bill 2. And Prayer for prayer, it's like stand.
Bless.
Stand like the CD.
It is your lordship.
Yes, my lord, we have, as per charge sheet not yet filed, my lord.
96 days today, lordship.
It was
For the
forwarded on
petitioner,
31.
learned edition and people. Was arrested on
Lordship forwarded on 31st 12 2025, lordship.
is directed that
Now, lordship, it is special session judge POCSO, lordship. Is from lordship Sribhumi, lordship. Special session case within bracket POCSO 26/25. Highly obvious.
49 my lord, charge sheet submitted.
On interim bail, my lord.
Case number 57/2026 dated 29/3/26.
Interim order will continue.
Yeah, I'm sorry, my lord, CD not.
is an interim lordship. Interim is their lordship.
Up to
Okay,
the
now,
CD
so
not.
and so.
May. May.
Yeah, please, your lordship. My lord, here in this case, lordship, out of the same incident, two FIR lost. First FIR is lost by the police and second FIR is lost by another private individual. Lordship, FIR, first FIR, lordship, in the first case, your lordship will find at page 14. 1-4.
Yes.
My lord, the actual fact was that this victim, lordship, alleged victim Rashidul Sheikh, my lord, he was caught in red-handed while she was involved with the physical relation with the petitioner number one's minor daughter, lordship. Thereafter, lordship, he was detained and a large number of village people were gathered. Police came and thereafter some altercation took place between the person who were gathered in the place of occurrence with the police, lordship. And this present petitioner, lordship, they are the family member, and more than, lordship, 1,000 people were gathered. And some altercation took place. And the police lordship has alleged that one of the police lordship has sustained grievous injury lordship. The lordship will see on that part. And so far the allegation is concerned, the actual fact was that this Rashid.
He's got red-handed. Does it give you a license to tie him up, attack him,
No.
and demand
The-
money for his release?
His present petitioner lordship, they were not at all involved in that incident, because some other people lordship, they were gathered in that place of occurrence.
Your name?
We are not saying all the petitioners' name is their lordship. Accused number 1.
All are named in the FIR.
All are family members. All these.
All are named in the
yes,
FIR.
Yes.
Then
1, 3, 4, and 7, and
the
others.
person was recovered from your house. Person was recovered from your house.
Procedural, yes, he was detained while he was involved with the sexual activities with the daughter of the petitioner number 1 lordship. We are not saying that he was not detained. He was detained, but village people lordship, they were gathered and they have made that incident lordship. Some untoward situation was there. Those people also have made that untoward situation lordship. In
Yes,
fact,
please.
this family member of this petitioner lordship, they informed the police regarding that incident.
What my learned friend has stated. But it is not as such, it is in the CD, as per the CD. The CD reveals what is in the FIR, it reveals the same thing in the CD lordship. And however, there are 2 CDs. And in 2 CDs, I have found lordship that there is in one of the CD, it is also stated that lordship in point number 6, the arrested accused person has been threatening and intimidating the victim, Rasidul Sheikh, as well as various witnesses demanding that they withdraw the case. This is the first point, lordship. They are threatening. Second point is that, lordship, there is also what I have seen, lordship, there are window sill glass of the police vehicle, rear views, mirror, window slides, mirror, all are damaged, lordship. This shows that something has happened and they have obstructed the police officers. And I have not seen any motive, lordship, for the police to do such type of things. They have not also stated the same thing, lordship. And moreover, if I look into the things, lordship, the victim has clearly named these persons, as it is in the FIR also, lordship, in the his statement also. It is the same thing. There are many witnesses are also. They have stated all these persons' names, lordship, that they came, and they have also demanded 150 lakhs, 1,50,000, lordship. It has not been recovered yet, and his mobile has also been snatched away. That also has not been recovered, lordship. So these things are definitely there. In police have lodged this FIR because they have attacked police, lordship. It is because of that. Otherwise, there will not have been 2 CD FIRs, lordship. It is because the police has also been attacked. It is because of that. So otherwise, lordship, these things are there.
Your lordship may kindly consider what is the injury.
Injury.
They are saying that
Injury is also, I will come into that, lordship. Injury is there, that the one Atwar Rahman, that is one of the Hawaldar, lordship. He also sustained simple injury, though it is simple, but there is altercations are there. It is proof, lordship. And moreover, there's Azizul Hussain, lordship. He also sustained the injury of, lordship, simple injuries on the forearm and on head also, lordship. Abrasions are on forehead, pain, swelling, these are things. And moreover, the victim also has been there, swear over lips, swelling over back of the head, then pain over chest, lordship. And these things are there, lordship. Though they are simple, but some altercations are there. It is there, lordship.
Not denying that some altercation was not taken place.
And he is also found in his house, lordship. Why he was taken to these persons? Why he has done these things, lordship?
Not because all the family members are lordship are implicated in this case, lordship. The police has implicated them. That's why, lordship, they are unable even to lodge an FIR against the Rashidul Islam, because police are lordship against these persons, family members. Lordship, large numbers of people were gathered in that incident. Because Rashidul was caught in red-handed. Moreover, they have beaten the police officials. Why they have hit, broken, damaged the police vehicles, Lordship. Just
But so far threatening is concerned, my friend is saying that threatening he's saying that the arrested accused person. Some other people, Lordship, others accused.
Anyway, material is against you. Let us CD now. Here is bail.
Obviously, Lordship, your Lordship will kindly consider this FIR is lodged by the police. And the CD is also, Lordship, prepared by the police, Lordship. We cannot expect that materials will not come. Obviously, they will implicate. Ambition, Lordship, this family members, Lordship, and say petition number 4, Lordship, is a woman, Lordship. Any stringent condition, your Lordship may.
Second case is the one lost by the
Official, Lordship. One is the police official, another is the wife of this procedure. These two cases are there.
First case is lodged by the police.
And the petitioners are both in both the cases, the petitioners are the same.
Same incident narrated in the FIR. Second case is Rashidul himself lodged the FIR.
They also demanded 5 lakhs also, Lordship.
that is
They have also
baseless.
taken 1,50,000, Lordship. They have
That
not
is-
recovered yet.
That is totally baseless allegation, Lordship.
Come up in the trial, Lordship, it is a baseless on, but prima facie case has been established, Lordship.
All other accused were arrested, and apart from this, Lordship, other family members who were not even in the FIR, they were also arrested, and they subsequently released on bail.
One of the section is 310, Lordship, that is dacoity. Because there are more than 5 persons and they have taken 150 lakhs, Lordship, 1,50,000.
What circumstances he has taken that money? 1,50,000 in cash. That he was involved in the POCSO activities. Minor daughter.
was the fire.
These petitioner are apprehending, Lordship. They are unable to even, Lordship, approach the police, Lordship. Because the police are running against the, after them, Lordship. All the family members are targeted by the police. When the other women were also taken, Lordship, in custody. Yes, Lordship, such incident, Lordship, is if the such incident is taken place, 1,000 of people is gathered within a minute, Lordship. Such an event, Lordship.
You hand over the CD.
Awesome.
As per office note, there are 2/4/26.
Exactly.
Service is still awaited, my lord. They have taken steps on, my lord.
18/3/26.
18/3. Service. Otherwise, my lord, in the merit also, my lord, the girl, my lord, is 17 years old, and she in her 183 statement implicated.
All right.
Yes, madam.
Ordinance number. Waited, list again.
Immediately after reopening, madam. CD may be written, madam, in the meantime.
55, I am sorry, my lord.
There is by seeking bail, my lord, on the offense is registered by under section 21B. There is that some contrabands were recovered, my lord, from our
South Salmona Mankasa, my lord, on third
20. 23rd, my lord.
No.
District, my lord, program,
Sapatgram.
yes, my lord. And a petitioner is an interim, my lord.
Again on so and so interim
But
order passed
7th
earlier to continue the next day.
Interim may be continued, lordship.
7th of May, my lord.
Deeply.
Lordship, case is infectious. R.I. Mandal, on behalf of M. Hussain.
Sir, I
R.I. Mandal
of
M. Hussain. Obligation.
If the case and for mediation on 18 to
failed.
kindly fix the matter.
That the and for mediation failed. Here is the report. Matter for admission. Give-
May I please? Look here, the sessions case. I've stated. Page 6, my lord. Para 6, page 6.
mentioned. It's two.
Essence case number 5K, my lord.
Case number 75.
Bracket in bracket K, my lord. Oblique 2025
Of
pending, my lord. It's a convict. It is appeal. Page 6, para 6, my lord. I have essence case number 75 bracket K 15 under section 3. Passed by the learned additional session judge Kamrup Metro.
hence disposed of.